Hello, everybody. Welcome to our Chatting with Charlie EB-5 Investor Outlook for the month of September 2023. My name is Joseph Barnett. I am a partner at WR Immigration, and it is my honor to welcome you in. I can say if you're here live, we are very, very thankful. You can always put the chat and questions in. And for the thousands of viewers on YouTube, welcome. It is great to have you. I, of course, am joined by none other than Mr. Charlie Oppenheim. Charlie, great to see you.
Hello, it's great to be here.
And today we are talking about EB-5 Investor Outlook. It is a very fun an interesting time in EB-5 right now. And in particular, there's been a lot of good news and developments with EB-5 in the past month. Um, and combined with the new fiscal year, which starts next week, and the October Visa Bulletin that was released earlier this month, and all of the new visas that were allocated. It is a very, very exciting time, and we have a lot to speak about today. So buckle up and get ready. Um, the first thing I got to say is we say it every time once this thing clicks is that this is not legal advice. But if you want legal advice, hey, give us a call, WR Immigration, and schedule a consultation with one of our attorneys. For EB-5, we have a great team of attorneys working here at WR, and we would be happy to help you and journey forward with you. Again, my name's Joseph Barnett, here with Charlie Oppenheim. He's our director of visa consulting. And Charlie, can you do your brief, like 15-second bio? I kind of almost like just asking you to do it just for fun at this point. We've said it so many times, but it's so good.
Sure, I was chief of immigrant visa control for over 23 years prior to my recent retirement. During the time, my decisions allowed over 9 million immigrants or persons to immigrate to the U.S. I was regularly consulted by the White House and congressional offices regarding immigration reform issues and testified before Congress on 2 occasions.
Amazing. Thank you. And so you were really the chief author of the Visa Bulletin that's released every month, right?
Yes.
All right. And so when you were doing that, you would be working with USCIS, working with consulates around the world, trying to understand demand and supply for visas. And that obviously takes a lot of work and a lot of coordination. Yeah.
Right. I would work with USCIS to see their projections on employment demand in the coming months. And I would work closely with our overseas post to see what volume of work that they could handle in the coming months and express my desire for them to process if we saw that we were falling behind, for example, in the China employment fifth preference processing or whatever. I could see what their capacity would be in the future months to help catch up with demand versus the annual limits.
And so when the October Visa Bulletin is released, I imagine the month or so leading up to that is a very busy time for you.
Yes, typically before the October Visa Bulletin is released, we would work very closely with the Immigration Service to determine the application filing dates because we would want the application filing dates, which we announced in October, to reflect where we thought that the final action dates listed in Chart A would be at the end of the fiscal year.
And we're going to be we're going to be diving into that deeply today, talking about Chart A, Chart B, what it means for those who filed before the EB-5 Reform and Integrity Act are in that unreserved category, and as well as what that means for those who are filing after the Reform and Integrity Act in those reserve visa categories. About our firm, we are one of the top immigration firms in the US. We have a great great team. I think the strength of our firm is our team. We obviously have this great technology called Rapid, which we have developed in-house, but really the strength of our firm is our team. And I don't just mean the partners, it's everyone who works here, my paralegals, administrative staff. It's an incredible place to work, and we would love to journey forward with you. So let's get into our EB-5 roadmap, what we're going to be talking about today. The fiscal year starts next week. You guys may have heard there could be a government shutdown, and because they don't have the money to fund the government when it starts. Thankfully for EB-5, that is less of an issue than it has been historically. And every fiscal year, there is that new group of visa allocation that comes out. And so that's why we see a lot of movement in the Visa Bulletin, or can at least see a lot of visa movement. Then we're also going to be talking about IPO processing of EB-5 petitions. And for prospective investors out there, we're going to be kind of talking about the different forms that must be filed and can be filed, and how USCIS will adjudicate cases in order, whether it's a project case or your specific EB-5 case, or potentially the interim benefits that you get by filing under Chart B. And so that's the last topic that we're going to be talking about today. All right, so this is Chart A for October 2023. It's for all of employment-based. We're going to first talk about the unreserved visa category for Chart A and for Chart B, and then we're going to come back and talk about the reserved. For the unreserved, those are folks who filed pre-RIA, so pre-March of 2022. They're the ones that, in my opinion, somewhat got screwed, but 32% of all EB-5 visas were taken from them. But those are the folks sitting, and it's current for everybody except for China mainland born and for India. But those advanced from last month. China advanced 3 weeks, and India advanced 17 months. So those are big advancements, and that's great news, something that we're very, very happy to see. Charlie, can you give us your thoughts on, I guess first let's talk about why you think Chart A advanced for India unreserved.
Oh, well, with India, when the date had retrogressed, the retrogression was basically to stop any use of India numbers at the end of fiscal 2023 because they had reached the India per country limit. With the start of the new fiscal year, there's a whole new supply of numbers. So they were able to have a significant recovery and try to take care of many of those applicants who were, very close to being finalized prior to the retrogressions at the end of during the summer. I think that the India date will continue to advance at a fairly steady pace during the course of fiscal 2024.
And that brings us to Chart B, where you said previously that Chart B is where the Department of State believes Chart A will be at the end of the fiscal year, in theory, or at least in conceptually.
Yes, in theory, I was a little bit surprised at the fact that the India date had jumped so much. The previous Chart B application filing date had been December of 2019. It is jumped to April 2022. That is a significant jump, but both the jump for the India date and the China date could be the State Department's effort to spur the IPO office action on the potential approval of pending EB-5 petitions, and in order to stimulate demand so there is enough demand to fully utilize all of the available unreserved numbers during the course of fiscal 2024.
And that relates to the visa availability approach, and IPOs, when they look at whether a visa is available, and whether you're sitting in a certain queue, which we're going to talk about, they look at Chart B. And so what I think, Charlie, you're saying, and correct me if I'm wrong, is that by pushing that out, there are now visas available for those individuals, which allows USCIS to take action on their I-526s.
Correct.
Excellent. And then I'm just going to go back to the full chart B here. And we also have China moving forward. Not as much, but still pretty significantly. 1 year movement forward. That is a big advancement. And I guess my question to you, Charlie, is there's chart A movement and there's chart B movement. First, let's talk about, I guess, maybe the less good news. Do you foresee the chart B movement? Do you foresee any forward movement on the chart B of these dates?
I wouldn't expect any chart B movement in the coming months. And a lot would depend upon if the State Department is seeing enough approved demand based on the movement of the dates that they have. If they are not seeing the expected amount of demand, then it is possible that they could make some corrective action on those application dates at some point during the latter part of fiscal 2024, potentially advancing the China more. I don't think that they would need to advance the India date anymore, but they could advance the China date some more. It's just a wait and see. But for now, I think everybody should assume these are the dates which will apply throughout the fiscal year and be pleasantly surprised if they were to advance any more.
Now that's for chart B. What about for chart A?
I think that we will see steady progression of the final action dates in chart A throughout the course of the year. So I think that they will move along, and in theory, they should reach the chart B dates by September. That is where the chart B dates are established at a point where it is believed the final action dates will be in September. So by listing a 2017 and a 2022 date for India or for China and India respectively, state believes that's where the final action date will be in September of 2024.
So this is a big opportunity for EB-5 investors because they can use that advanced date in particular. And if they're in the United States, they can file an adjustment of status. Previously, they may not have been able to because their priority date was not current under chart B, but it moved forward significantly. And that's giving a lot of opportunity for folks, for example, who filed like a Chinese national in the United States who filed an I-526 in 2016. Now they have an opportunity that just wasn't there last month. And even more so for India national who is in the United States. They are trying to spur demand for these visa numbers, which is good. We want to make sure that all of these visa numbers are used. So now let's talk about chart A and chart B, I guess, for the new set aside or reserve visa categories. Charlie, what do you see? What do you see there? Any changes from last month? Do you believe that there could potentially be the imposition of a final action date in the next few months?
I don't believe so. I believe that the reserved categories are likely to remain current throughout fiscal 2024. If any of the three were to require the imposition of a final action date, I don't believe it would occur before late in the summer. I just don't believe that the enough cases can be finalized in the early months of the year versus the annual limits to require the imposition of a final action dates.
Thank you. And so this
Oh,
really gets
one important thing, and it's something you usually mention because I forget. It is important to remember that the date which apply is if there is a date when the case is ready for final action, that is what applies, not what the final action date was when the applicant filed their petition.
Yes, thank you for that reminder. That's something I think is very important for everybody to understand, is just because it's current at the time that you file your I-526 and you, if you're in the United States, are eligible to file the adjustment of status application, that does not mean that there will be no final action date when the I-526 is approved, which is what allows USCIS to look to see if a visa is available in order to approve the adjustment of status. But that being said, and we're gonna get there a little bit later on, is you can remain in the United States and you can continue getting EAD and advanced parole extensions, even if there is some sort of retrogression. And so there still is a benefit of getting your spot in line and using this opportunity that Department of State is providing by pushing that Chart B date for filing forward so much. So this is something that a lot of prospective investors ask me about. And so I thought it would be smart to kind of go over the roadmap for how IPO processes petitions. And in particular, this is very interesting because we're actually starting to see I-526E petition approvals, which we just didn't have when we did our Chatting with Charlie EB-5 Outlook last month. And so the way that it works is a regional center must first file a form I-956F prior to any investor filing a form I-526E. The I-956F relates to the project. They look at the business plan, they look at the offering documents, they make sure it's credible and that the project complies with EB-5 rules. Once USCIS receives that I-956F, an investor is allowed to file an I-526E based on an investment in that project. However, USCIS will have to approve the I-956F first before it will adjudicate individual investors' I-526Es. That's important from an investor point of view because you want to ask, has there been an I-956F approval? And USCIS has started to do it. It's taking around 10, 11 months based on the data that we've been provided for USCIS to approve one of these project cases. Once the project is approved, what we are seeing in about a month and a half or 2 months later, USCIS is beginning to approve the I-526Es associated with that project. And we'll give you some examples later on. But this is important because it relates to the visa availability approach. And the visa availability approach is what governs USCIS IPO office's adjudication of I-526s. There's 3 different queues that they put I-526s in. The first queue are those where there are no visas available. So 2 things. 1, that's not applicable for the reserve visa categories because they are available for all of them. They're current for all of them. And really, it's not applicable to anybody except for those who filed after Chart B from mainland China and from India. So there's not too many in that Q1. I guess there actually are thousands of them from China now that I think about it. But other than that, those are the ones in Q1 waiting for the visa bulletin and their priority date to become current. Q2 is where I-526s are sitting when a form I-956F has not been adjudicated yet. So this is for everybody who has an I-526E pending where there hasn't been an I-956F approved. And I know I'm saying these forms like you guys should all know them. The I-956F relates to the regional center's project application. The I-526E relates to the individual investors application showing that their money was lawfully obtained. And finally, there's Q3. This is where the I-956F has been approved and a visa is available. And these are supposedly assigned to officers on a first in, first out order. It is unclear, there's been no announcement by USCIS whether the visa availability approach actually applies to post-RIA investors. But based on what we're seeing in practice, I think the answer is yes. And so what I wanted to do was give a shout, just a showing of what these different 956F notices look like for individual investors who are looking at projects and doing their due diligence. So we're looking at I-956F adjudications here, and pardon me for taking a sip of water. The one on the left is a receipt notice. It shows that this I-956F was filed in August of 2022. That shows that the case has been filed, and now an I-526E, that individual investor application, can now be submitted as well. On the right, we see the I-956F approval notice dated September 8th, 2023. And it shows that this I-956F has been approved. And it says there, determination of EB-5 compliance for this particular project. That means that USCIS can now adjudicate the Form I-526Es that were filed based on this project. They are now in Q3. They were moved from Q2 to Q3. Something that I have a lot of conversations about and I thought people would want to hear about. So this is some of interesting news. We got an I-526 approval in about 4.5 months. This was an Indian national living in the United States on H-1B, stuck in an EB-2, EB-3 visa backlog, who wanted more control of their immigration future. It was her and her husband. They filed this in April. They got adjudicated and approved without an RFE in September. This appears to show that USCIS is prioritizing the processing of rural cases. This was a rural case. It also seems to show that USCIS has divvied up their adjudication teams. There's apparently a pre-RIA adjudication group and a post-RIA adjudication group. Nobody in the industry knew how they were going to do this. They haven't announced it to anybody. But I have clients who filed back in 2019 who are still waiting for adjudications, and they see this and they think this is crazy unfair, and I don't blame them. And I also have prospective investors who are looking at this and saying, well, thankfully this is happening. I don't want to have to wait around for 4 years. So there are obviously some fairness issues in play here, which I can't really speak to, but or I can't speak to why USCIS made that decision, but it seems to me that there are two different groups of USCIS adjudicators, pre-RIA and post-RIA. We've now received, I think, 13 or 14 I-526E approvals, ranging anywhere from 3 months to 10 months pending. I have also heard through the EB-5 grapevine that they've started to approve EB-5 I-526E petitions based on high unemployment area as well. And the dates that I got, it was pending around 12 months. So they are splitting it up. And what this means in terms of visa availability and visa demand, Charlie, this is why I wanted to kind of give this background and then bring it back to you, is we didn't know previously how fast USCIS was going to adjudicate these. And we were concerned that these reserve visas were going to be wasted because there just simply wouldn't be demand for them. because they would just be sitting at IPO waiting for approval. Now that we're starting to see that approvals come in, there are signals going to the Department of State for demand for these visa numbers, right?
Yes. So once the petition is approved, if the applicant has indicated overseas that they will be processing overseas, the petition would be forwarded to the National Visa Center. The National Visa Center would be then eventually in contact requesting certain documentation to be submitted on behalf of the applicant.
And before we move to the next slide, which kind of gets in detail about that, I just wanted to make a point, and Charlie, so this says in the bottom right box there, reserved RR1, Rural Principal Regional Center and Investor. Well, what does that mean to you? Is that a code for the Department of State, or what does that signify?
Yeah, it's important that they do this because when the petition is forwarded to the National Visa Center, the National Visa Center needs to know in what queue the case should be put. For example, it could be an employment first preference would be EB-1, or second would be EB-2, or a family fourth preference would be F-4. So that's the way they would track it. And then when the applicant becomes documentarily complete, they've submitted all the required documentation, then the case is reported to the visa office so they can determine if and when the applicant can be scheduled for visa interview. So this is very important, and hopefully in November of each year, usually the National Visa Center provides state with information on the amount of applicants with a petition on file at the National Visa Center as of November 1st of each year. And that information is then publicized in the State Department website in December. So this will be very important. It's going to allow us to see how many case applicants are pending for overseas processing.
Thank you. And do you have any idea why it says unreserved in this approval notice? If it was just a rural reserved visa category, I don't know. I mean, maybe it could just be a new thing that.
Well, this is an interesting issue. The fact that if I were just looking at this, I would almost say that would allow the person to be processed in either the reserved or the unreserved. And if that is what they've decided, then the RU would throw it into the unreserved processing area, just like an I-5 or a T-5 would be.
Right.
And then the reserve bucket of numbers would be the RR. So it's an interesting, it's kind of interesting.
Yeah. Yeah. We're just starting to get these approval notices. So there are some unanswered questions that we have. And this is one of them, is what exactly is USCIS thinking when they put this unreserved number, or RU1 in the reserved visa approval notices. So this next slide that we have here relates to fiscal year 2024 EB-5 visa availability. And it assumes that the annual limit for employment-based in total is 150,000. And 7.1% of that is 10,650. And so that's the number that we are assuming. And the Department of State hasn't really come out and said what it will be for fiscal year 2024. And we await the news on that. But as we've said in prior webinars, the reserved gets 32% and the unreserved gets 68% of that annual limit. And so that's what the blue is for reserved and the green for unreserved. We've also mentioned that the Reform and Integrity Act allows unused reserved visas from fiscal year 2023 to be used in the reserve visa category for fiscal year 2024. And so when you add in the unused 4,476 reserve visa numbers from this past fiscal year, that's where you get that 7,884 total reserve numbers that are available for use in fiscal year 2024. And we don't know actually if any reserved visa numbers will be used by the end of fiscal year 2023, so pretty much by the end of this week. But our assumption is that there hasn't been, because USCIS just simply hasn't been able to adjudicate I-526Es quickly enough. But potentially there could be a handful, right? I mean, in theory, maybe if there's like an adjustment of status. I mean, I haven't heard of that, but in theory there could be. I don't know, Charlie, any thoughts on that?
I would be very surprised based on the normal processing times, even if the petition had been approved, say in July, it is unlikely, I believe, that the Immigration Service could have adjusted it by the end of September. But stranger things have happened. We weren't expecting the amount of approvals, petitions approved in the reserved categories. So no telling what immigration is doing at this point.
Okay, that's sort of, I won't say music to my ears, but that underscores the assumption here that all of those numbers from fiscal year 2023 in the reserved visa category could be made available in fiscal year 2024. And in the next column, we kind of break it down by the actual reserved visa categories on how many visas are there for each one. So, 4,900 or so in the rural category, 2,400 in the high unemployment, and just under 500 in the infrastructure category. And then you break that down even more by the per country limits, and that's what you see on the screen there, 344, 172, 34. Now, that does not necessarily mean that mainland China will only get 344 reserved rural visas, or that India will only get 172 high unemployment visa numbers in fiscal year 2024. That's just what the per country cap is. And Charlie, maybe you can give us a little bit of background on or thoughts on the otherwise unused rest of world visas and how that would play out for these reserve visa categories.
Right. What state would look at is if, say, for example, in the rural, they see that the limit is 4927. They would assume that China is going to use all 344 available to them and India as well. So they would subtract those two totals from the 4927. Then they would make an estimate of how many numbers they believe the rest of world applicants are going to use, and then subtract out that, any remaining balance would be considered otherwise unused, and they could be made available to any country who had already used their per country limit, and the numbers would be provided strictly in priority date order without regard to the individual country. So this bodes well for Chinese and Indian applicants.
That was so succinct and it made so much sense to me. And I really hope that got through to all of our listeners here because it's so important. We're always worried about these per country caps. It's something that you hear about a lot in EB-5 and in particular in EB-2 and EB-3. But the point that I want to make here is that the visa numbers are so big that 4,927 is that there's going to be significantly more visas available for these very, I guess I would say, where demand for these visas are very popular. And what we're seeing right now, that's mostly China, India, Korea, Vietnam. I mean, I think, and that gets to the point that Charlie mentioned earlier, in that for the visa bulletin, it's unlikely that we're going to have any sort of final action date in chart A or application filing date in chart B imposed in fiscal year 2024 because these limits are just so big. Is that accurate? Or at least maybe not until next summer, the summer of 2024 is what you were saying.
Correct.
And as we keep going to the right on the slide here, we take the green 7,242 from the annual limit in fiscal year 2024, and we add that over, we add that to the unused reserved visa numbers from fiscal year 2022 that weren't used, and that's where you get the 13,638. And when you add it all together, at least according to my calculations, after the carryover, there's over 21,000 EB-5 visas that are available for use in fiscal year 2024. That's a lot of numbers. And if used and done correctly, can really reduce that visa backlog. One of the things that USCIS just reported, I think it was earlier this week, or maybe it was last week, was the number of I-526 and 526Es that have been submitted to USCIS from March of 2022 to June of 2023. And they said that there were under 1,900 of these cases. And that's actually a good amount. Previously, it was 1,217. So in about 1 month, there was over 600 of these cases that were filed. And so that's sort of the demand that we're seeing for EB-5 right now. It's definitely significant. And why that number is important here is it gives us an idea of what the demand for these visa numbers will be in the future once USCIS approves the cases. And as we mentioned in the previous slides, it seems like they're going to be approving these cases quicker than we had originally thought. And because of that, the visa number usage will occur quicker than we thought. So Charlie, I know USCIS hasn't given us the breakdown of, hey, the X number of filings based on this country of birth and this reserve visa category. But when you see that 1898 number and you look at the per country limits that we have on this chart, how does that impact your thinking in terms of what you expect to see in the visa bulletin?
I think that it really does not concern me in terms of the implementation of a date. I think that we hope that there is as much number use under the reserve categories as possible this year, because we do have high annual limits, and we want to maximize number use so that there is less demand for numbers being carried over into the 2025 use.
And so, and I guess what is the big benefit of that? If we have more visas that are used earlier, how does that benefit investors later on?
What it would mean is we would work through so many more of the applicants who had early reserve priority dates of, say, 2023, and hopefully get through the majority of those cases, so that the cases being processed in fiscal 2025 would be those applicants who had filed in late 2023 or early 2024. So again, I think this bodes well, that the fact that the Immigration Service is approving petitions at much earlier than we expected, which will allow more number use during fiscal 2024, when we do have much higher annual limits that are likely to be in place in 2025.
Thank you. I hope that was clear for everyone. It was clear for me. One of the things that impacts visa number use is obviously the adjustment of status usage of the numbers. And that's all done for folks who are in the United States. And what USCIS has said is that for all employment-based visa categories, you use the chart B when you're submitting the when you're sitting in an adjustment of status in October 2023. And the way that it works is that when you file your I-526, you're also able to file an adjustment of status because it is current, or if your priority date is current for unreserved China and India. And your 485 will remain pending until your I-526 is approved, at least. During that time, you are able to file what we call for interim benefits, which is the employment authorization document by filing the I-765 and the advanced parole document, which allows you to travel during the time in which the adjustment of status is pending. That's the I-131. So for folks who are in the United States, that allows you to remain here. And once you have that EAD in hand, that allows you to work here without restriction, even before your I-526 is approved. That's a huge benefit. And by pushing Chart B forward so much and allowing Chart B to be used for the adjustments, that's a big opportunity for folks. And the other thing that's great is that USCIS now allows Chart B to be the time of visa availability under the Child Status Protection Act. And so for folks who are filing, you may be able to qualify as a child, even if the child turns over 21 during the actual adjudication of the adjustment of status. Now, this obviously brings up a host of issues as relates to immigrant intent and misrepresentation during entry with a non-immigrant visa. These are all very fact dependent. And you need to be very careful here, because if you try to get an immigration benefit through misrepresentation or fraud, then you could be barred for life. And so, this visa bulletin came out, Chart B we saw was being used for adjustment. And of course, we get emails and phone calls saying, hey, can I enter on my visitor visa and file an adjustment of status? And the answer to that question is no, you can't have immigrant intent when you enter on a visitor visa. And so we have to be very careful on how to advise clients, and clients obviously are the decision makers here. They need to be very careful on the decisions that they make. I mean, even enrolling your child in school while here on a visitor visa, and you're going to wait, I don't know, 60, 90 days to file your adjustment of status, like that action is inconsistent with your stated intent when you came in on a non-immigrant visa. And there could be issues with misrepresentation and fraud later on. And it's something that is it's a very tricky situation. And please speak with a qualified immigration attorney when you are thinking about taking steps with this regard. Let me see if I have any other notes that I wanted to say about this slide. My apologies. Oh, one thing I did want to say, let me go back. One is that in fiscal year 2023, the unreserved limit was 9,511. And based on the data that DOS has provided in their monthly statistics, to date of that 9,511, over 7,200 of those had been issued by U.S. consulates as of July 31st. And so that leaves just under 2,400 visa numbers that are unreserved to be used by adjustment of status applicants or by consulates in August and in September of 2023. It doesn't seem like, based on my experience, that there's going to be a lot of wasted unreserved visa numbers this year, we're going to have to wait and see with the Department of State's annual report so that we can really have a good understanding of that. But I don't know, I saw that the other day and I thought that was something important to share as well. Actually, before I go forward, Charlie, do you have any thoughts on that?
No, I think you're absolutely right. And I think this is encouraging news that the State Department has been able to do this. It indicates that they're basically back to have returned back to normal processing and are attempting to maximize number use under all of the various preference and annual limits.
Yeah, I thought it was good news too. So this year, I spoke earlier about interim benefits when your adjustment of status is pending. That's your EAD, your employment authorization document, and your advanced parole. And the big thing is that when you file your I-526, and you're in the United States, not only do you get your earlier priority date, which gets your spot in line, but it also allows you to file that adjustment of status and the EAD and the advanced parole applications. And like I mentioned earlier, if there is a final action date later on, well, you could still remain in the US because you have a pending adjustment, and you can still file extensions on your EAD or on your advanced parole during that time because your 485 will remain pending. So those interim benefits associated with it, you can continue to get extended. And your 485 will remain pending until your I-526E is approved. And if you're no longer current because there is some sort of retrogression later on, well, okay, so they can't approve your I-526E and they can't approve your adjustment of status, but you can still remain here and you can still work here. And so that is kind of what I wanted to show with this slide here. The other thing that I wanted to show was look how quickly some of these came in. 2 months, 3 months. And I can't guarantee that that's what's going to happen. USCIS processing times online show a wide range of processing, anywhere from 4 months to 10 months on an EAD, anywhere from 7 months to 18 months on advanced parole. That's what, and it's, to be honest, it's unacceptable in my mind. It takes them 12 minutes and 15 minutes to do this. I think it is a lack of capacity or potentially incompetence. I'm not entirely sure why it takes them so long to do this. But these interim benefit applications can take longer than any of us want to. But sometimes, hey, look, sometimes they squeeze in. And I have a client who was very, very happy, who was able to now leave their H-1B employer and start working for themselves because they have that EAD. So it is an excellent option and it provides a lot of opportunities. This is why EB-5 has been so popular, why over 600 of those cases were filed in the past 3 months. It's because they're just opportunities that exist now that just merely didn't exist before. And I think as people learn and understand what they are, and when they look at the EB-2 and EB-3 backlogs, they see the writing on the wall and they're looking to another option. So with, I want people to, if they have questions, please feel free. We have a couple that we're going to go through. Let me open that up. But with that, I really appreciate those who were able to join today. You can always reach out to me. My email is under my picture, my terribly old picture, which needs to be updated. But my picture, jbarnett@wolfsdorf.com. I'm happy to take any criticism, questions, or salutations. Please feel free to send my way. One question that we have here is, will the risk of shutting down the government impact the progress on our I-485 adjustment? Okay, that's a good question. My response is no, but possibly. I don't think it will. USCIS is a fee-based agency, and they are supposed to charge fees in order to process the case. I do believe that they will have adjudicators who will be able to process these cases. Is there a risk that it slows down? Yes, I think there is. But I still think they will continue to adjudicate them. There may be less folks working on them, but they will be adjudicating them. All right, for China unreserved investors currently in H1L1 status in the United States under Chart B, but not Chart A, can they file NVC consular processing and adjustment of status at the same time? So they wouldn't be able to do consular processing unless they are current under Chart A. But if they are in the United States and current under Chart B, yes, they can file their adjustment of status. That's my answer. Charlie, do you agree with that?
Well, they can use, if they're processing overseas, the National Visa Center would notify them to begin assembling certain required documents based on the
On
Chart
Chart.
B dates. And they could begin submitting the documents. And it is always best for somebody processing overseas to process and supply the documents in a very timely manner, because it is not until NVC has reviewed the documents and they're documentarily complete, and at that point, the applicant would be eligible for scheduling for an interview when and if their priority date is reached by Chart A.
Good point. But the consulate won't actually schedule the interview until the
No,
visa is available under Chart
correct,
A. And my
correct.
thought is, oh, sorry, go ahead.
But again, it is important to get the documents in so that the NVC would report the person to the State Department for potential scheduling in the month in which their priority date is reached by Chart A. So again, do not, I would suggest not waiting until your date was within Chart A, but proceed, if you're requested to do so, to supply documents based on Chart B.
Thank you. Oh, here we go. All right, I don't think we have any other questions, just a few today, so that's all right. But please feel free to reach out if you do have any questions. We are very happy to have you join us today. Thank you, Charlie, as always, for your great contributions and insight. And we hope to hear from you soon and journey forward together. Thank you.